The letters SAE are spelling trouble for at least a second time. That's the National Fraternity Sigma Alpha Epsilon. It's the fraternity that got itself kicked off campus at Oklahoma University and two of its members expelled for singing ugly racist songs. Well, now things are getting worse. At another campus, the University of Washington, Seattle, a black student group says they were heckled and insulted with racial slurs by members of SAE.
That's when they started shouting and then flipping us off and started saying, like, "You apes, why are you here? Get out of here."
It's just absolutely unacceptable and something we would never just let slide by.
We are ultimately trying to find the truth about the matter. Every member of my organization is as offended and frustrated by the situation as the BSU, in my opinion.
All right, let's bring in our legal guys. Avery Friedman, a civil rights attorney and law professor in Cleveland. Good to see you. And Richard Herman, a New York criminal defense attorney and law professor, joining us from Las Vegas. Good to see you as well. All right, so these two allegations, now we're talking about OU and University of Washington, Seattle, plaguing this frat, and now SAE has hired a big-name attorney. Listen.
As I said at the beginning, this matter is not one that seeks a legal solution. We seek to invite the university and its leadership, President Bourne and his designated representatives, and where appropriate, we consider it a good idea to invite representatives of the American Civil Liberties Union in Oklahoma and the state and perhaps Oklahoma City chapters of the NAACP. We believe that working together in a positive manner, we can find a solution that is acceptable to everyone to make this a teachable moment and an educational moment for what is seriously a flawed incident.
All right, so that's attorney Stephen Jones. He represented Timothy McVeigh in the Oklahoma City bombing of the federal Murrah building, and so now he's representing SAE. So what is the objective here? You know, Attorney Jones says this may be an issue of due process denied, particularly in the case of Oklahoma University, Richard, that expulsion happening before due process. Is this a valid direction?
You know, Fred, Mr. Jones is a sophisticated, very bright attorney, and he knows, like we've talked about before, for about $250, anybody can sue anybody. And here, technically, are there due process violations? Yes, there probably are. Could there be a due process hearing? Yes, there could be. Do we know the result of that? We know the result of that. Here's the situation, Fred. This timing could not be worse for Sigma Alpha Epsilon, with the country reeling from Selma, the anniversary of Selma, from Ferguson, from Garner in New York. Racism is on #1 on the list these days. And to have an incident like this at the University of Oklahoma and get magnified to the extent that it is unbelievable. Now, this is not a local fraternity. It's a national fraternity. And I read in the paper today, the national fraternity has disbanded the fraternity at the University of Oklahoma. So they don't exist anymore, whether the university does it or not. They're gone. So I looked at their mission statement. I picked out their mission statement. And the creed that this fraternity goes by is, we like to be deemed true gentlemen. That's their mission statement. They have utterly failed.
It doesn't matter what their mission statement is.
I don't think there can be any resolution here to bring this fraternity back. It's over. They're going to be ostracized.
And now what about the students, though? Because the parents of the students might want to say, wait a minute, should my kids have been expelled on these grounds? And so, Avery, if we're talking about due process and we're talking about this attorney saying they had the right to at least give their side of the story before being expelled, but at the same time, isn't there a code of conduct, an expectation of students' behavior on campus? And does the Oklahoma University President David Bourne have this discretion to say, this violates the code of conduct, and so you're out of here without legal challenge?
Doing legal analysis, not talking about gentlemen. What the legal analysis is here is, as an organization, SAE has absolutely no due process rights. They are gone. They are there as a privilege. The individuals, however, Frederick, and this is very important.
That's wrong.
It is a public university. They are entitled to notice. They are entitled to a hearing. David Bourne, who frankly is wonderful, but he should know better, should have suspended these students, given them notice about what they did wrong, and had a hearing. And based on that evidence, he has the right to do the appropriate remedy there. But The violation of rights is not even in question here. These students have a right to a hearing notice, and the summary expulsion was absolutely unconstitutional.
Really? Okay. So on that note then, Richard, you know, we are talking about a public university, and that means that all students should feel comfortable being able to attend, go to this school. But if you have racist chants, that certainly creates a, you know, an unsavory atmosphere, an uncomfortable atmosphere, and thereby the president would have discretion to say this behavior is unacceptable, or on the grounds of First Amendment rights, will he be challenged?
You know, Fred, the university is partially federally funded and state funded. There are constitutional protections afforded to the students of this fraternity. But we know the result of that investigation. We've looked at the video. It's not any great shakes that are going to be uncovered in this investigation.
Prejudge it.
That's why the attorney is very sophisticated. He's trying everything in his power to try to keep the fraternity alive by entering into some sort of rehabilitative, some sort of approach. The issue is this: they are entitled to the process. They will lose.
And who would it benefit ultimately? Because, I mean, one of the two parents of the other young man, Levi Pettit, who was also expelled, said he's going to have to live with this for the rest of his life. And so the damage is done. So how could, I guess, the reputation of the kids be resurrected, or even SAE from an incident like this?
SAE is gone, Frederica. The reputation of the children may be gone. The issue here is due process. Those kids have the right to a hearing. This has been a meat cleaver approach when they're supposed to be using a surgical scalpel. If not, you throw away the Constitution. Their behavior is reprehensible, but we have a process, Frederica, and when we throw that away, the Constitution is nullified.
So quickly then, does this mean that the parents or even the students will be able to sue the school?
They potentially could sue the school, but the attorney is telling us he's not going to sue the school. He doesn't want to sue the school.
He's trying to
settle it. It sounded like nothing was definitive. He even said he's not really sure which direction we're going to take.
Right, and there's still an investigation going on.
It's going to get settled. That's what's going to happen.
Okay, Richard, Avery, thank you so much. Always appreciate you, gentlemen. Even more fun when we're all talking at the same time. But somehow I still understand everything. All right, good to see you guys. Thanks so much. See you next weekend.
Take care.
Much more in the newsroom right after this. Prosecutors in Wisconsin say two young girls who tried to kill a classmate in order to please the horror character Slenderman should be tried as adults. The girls were 12 at the time. They lured another girl into the woods and then stabbed her allegedly repeatedly. An attorney for one of the girls says the case should be moved to juvenile court. Well, now we're getting a chance to hear from the girls themselves. Their words are very chilling. Nick Bohr with our affiliate WISN has the story.
While the two then 12-year-olds are charged with trying to kill their friend last Memorial Day weekend, the fictional creature Slenderman is also a central character. In the recorded interviews with police, for the first time we hear them explain Anissa was first to come across his tales on a website called Creepypasta Wiki.
It's full of horror stories that are meant to purposely scare you. He has these proxies or servants, as people call them.
And Anissa says once she showed the stories to Morgan, the two quickly came to believe the stories were real.
Morgan said, "Hey, Anissa, we should be proxies." And I was like, "Okay, how would we do that?" And she said, "We have to kill."
Morgan admitted the plan targeting her longtime friend was hard to explain.
She was my only friend for a long time because.
Why would you hurt your only friend?
It was necessary.
These interviews are only public because their attorneys introduced them as evidence. We wondered why they would want such an unflattering picture out in the public. Prominent defense attorney Craig Mastantuono, who isn't representing the girls, explains.
You're always a little worried about how your client presents for potential future proceedings. Here there appears to have been a decision made to present video evidence because it would support a second-degree intentional homicide attempt at this critical early stage that could get the children back into juvenile court.
That means demonstrating the girls truly believed Slenderman was real and was a threat to them and their families. In Milwaukee, Nick Bohr, WISN 12 News.
All right, let's bring in our legal guys now. Avery Friedman, a civil rights attorney and law professor, joining us from Cleveland. Although you should be here in Atlanta, but we'll make
should.
arrangements. We're going to have to, get our calendars together. And then Richard Herman, a New York criminal defense attorney and law professor, who did make his way here to Atlanta. So we will, we're throwing you a big old hug, though, Avery. Long distance.
There we go.
Okay,
there we
good.
go.
All right, very serious topic. Let's talk, now about whether these girls should be charged as adults. We're talking about Morgan Geyser and Anissa Weir. They've been charged with committing attempted first-degree murder. In Wisconsin, that automatically places the case in adult court. So, Richard, is that where it belongs? Of course, their attorneys are arguing they were just 12 at the time. This should be in juvie court, but should it?
Right.
How do you make that determination?
That's the argument. And the issue is, can a 12-year-old be rehabilitated that they have a chance at life, to live a life? If they're tried as adults, and the prosecutor had the choice here to go with first degree or second degree. Had he charged them with second degree, the girls could have been tried in juvenile court, faced a situation where, if convicted, stay incarcerated up to about the 25 years of age, get rehabilitation and treatment. That's what they need. And then have a chance of life. If they get convicted now in adult court, charged as adults, they can get up to 65 years in prison. They're going to be in prison for the majority of their life. Is that right? That's the moral dilemma here.
So then, Avery, doesn't the argument also have to be made about whether these young girls knew what they were doing? Were they psychotic? Were they delusional? When you listen to the audio tapes, the videotapes of these young girls, at least one of them, talking about, it felt like air. It didn't necessarily feel like she was stabbing a person, but they couldn't stop. And when you hear that, you wonder, is there a mental argument to be made here of them not really physically and mentally being present at this moment? And does that assist in trying to determine whether they should be tried as adults or juveniles?
Well, and that's what the judge in this case, Frederica, is going to have to conclude one way or the other, and we're expecting that ruling on the 13th of March. For me, in terms of my service as a probation officer, the juvenile court, for my years as counsel, and even serving on the bench, I'm absolutely convinced that when you're, and by the way, the plot for the stabbing was developed when they were 11 years old. It was the 12th birthday that preceded the stabbing. But there is no way on earth. We've heard medical testimony about the incapacity of children at this age, these two girls. So it strikes me that even though the prosecutor is going to try them as adults, and there's precedent, believe it or not, in Wisconsin trying 12-year-olds as adults, I think ultimately this case belongs in juvenile court.
You do.
If there's any chance of rehabilitating these children, it should be exercised. Warehousing them for a lifetime, Frederica, is the wrong thing to do.
Huh. And you're in agreement with that too, Richard?
Well, Fred,
I guess I'm surprised to hear both of you, talk about that, because we're talking about such a heinous crime, and we're also talking about, stabbing seems like a much more passionate way of murdering somebody. And
planned.
Especially planned, nearly a year in advance. And it almost seems like, an argument can be made that maybe these young girls, even though they were just 11 in the planning and the 12 of the alleged execution of this crime, that they're also a little precocious, that, maybe they were a little bit more adult or, bigger than their years. And because this is such a heinous offense.
Well, Justice Kennedy of the Supreme Court recently opined that immature kids lead to immature acts in sum and substance. But here, Fred, one of the girls was diagnosed with schizophrenia, and it's believed by the interviews that they've had with medical personnel that they truly believed if they didn't kill this girl, their family and friends would be killed by this Slenderman. So
then the makers of a Slenderman, would they in any way be held, culpable, liable, being instrumental in luring or convincing these kids to do this?
I don't think so.
No.
I think the thrust here is going to be...
I think that's a great question, actually.
Yeah, but will these young girls who are now 12 years old, will they have a chance to live a life after the age of 25 if they get convicted?
Yeah.
Or are they going to spend perhaps 65 years in prison? Wisconsin's a very difficult state for this type of prosecution. They allow it, as Avery said, and we'll see.
All right, before we go, Avery, real quick, why is that Is there a little window of opportunity there, possibly, in that argument?
You know what? I think some of the parents knew that at least Morgan was involved in this. That's a question, a civil question, that really needs to be answered. We balance that against First Amendment, freedom of expression, but you know what? I think children, vulnerable kids, can fall prey to this sort of thing, and that's a question that remains to be seen, and I don't know what the answer is.
I know. All right. Avery Friedman, thanks so much. Richard Herman, and we got a nice little shot of your tie, Richard, while you're here. that was just a funny little camera move.
Nice tie.
We got a little creative there. All right, good.
And thank you, Richard, for warming the seat up, by the way. Thanks for
That's right. Because, you know, we got another seat for you here, Avery. So when we get our calendars together, the three of us will be here, you know, arm in arm. It's going to happen soon.
Wonderful.
All right, thanks so much. Much more in the newsroom after this. Thanks so much.